Hey, I trust your judgment.
Hi, good afternoon. Thanks for watching this month's Lawyer and Friend Talk. I'm the presenting attorney Bingchen Huang, and to my left hand is my friend and our old friend, and also our firm's managing partner, Mr. James Collins. So before we start, we do have to give a disclaimer that this is an attorney advertisement and majorly serves pedagogical purposes. It is not a legal advice and does not constitute attorney-client relationship. With that being said, we do think that it is always wise to get mad because we are really good.
We're the best.
Yeah. So, next slide, please. Today's presentation theme is the procedure pitfalls in the workers' compensation system. Civil procedures are very nuanced and detailed and sometimes technical. As claim managers, they may not appear on your daily life, but I do believe that you may have recollections being asked by the handling attorneys about certain litigation nuance. They could be like when it was sent, like how it was sent, or maybe even like which vendor did you choose. So one of the purpose for this presentation is to explain the background stories on the attorney end. Uh,
Yeah, this is a topic that you may not see very often in your claims, but when it does intrude itself into the merits of a claim, it can be really disconcerting. And so I thought this was a great topic, Bing, because it's something that's not seen very often. There are things that are just done automatically by either a vendor in the case of an IME or by us as defense counsel in the case of scheduling of depositions or what have you. And so understanding what is going on in the legal context is good because occasionally these procedural issues intrude themselves into the merits of a claim.
Yes.
We just had a claim this week decided awarding no permanency to a claimant who had, an apparent otherwise valid claim for permanency, but that claimant's doctors were precluded on deposition failures. So this is something that ultimately can be very valuable for everybody to avoid mistakes and to enforce penalties when mistakes are made by our opponents.
Yes,
Slide, please.
So the first topic we are going to cover is the IME and record review. And on the second part, we are going to discuss the scheduling of depositions of doctors.
Slide.
Next slide, thank you. Yeah. So if one line is used to conclude the procedure in the workers' compensation system, it has to be that, well, wait a second. The board is not bound to any formal or technical procedures.
Right. So this is the end of the presentation, isn't it?
Well,
Like the top line rule is that there are no rules, so there can't be procedural pitfalls, right?
Well, I wish, James, but as later we'll explain in the presentation, it's not really true. So my understanding of these holdings is that the third department is essentially emphasizing, the concept of fairness and equity. Well, at the same time, if you look at the case laws, you'll find that the statute, the codes, regulations, and the precedent case laws are largely followed. So I do think that there is still value
Okay.
to know that this feeling.
Listen, you were going to get high marks for doing a Lawyers and Friends that only lasted 5 minutes, but I guess we'll go on to the next slide and see what rules we have, right?
Yeah. So this goes to our first topic. Oh, that is the IME and the record review. So a record review is mentioned separately because technically a record review is not governed by WCL section 137, and it is solely regulated by the New York Code Rule and Regulation 300.2 subsection D. However, as we'll later explain, there are essentially no much significant differences. And for the purpose of this presentation, it would be safe to just remember one additional requirement. Next slide. Thank you. That is, for a record review, there is an additional requirement that it must be presented to all the parties and the board at least 3 business days before the hearing.
So my recollection when I examine this issue is the board loves to say that Section 137 doesn't apply to record reviews.
Yes.
But then when you read 300.2, all the same requirements are in 300.2 essentially, plus potentially what we would call an additional rather than a substitute requirement, the 3 business day rule. Because for years before the regulations were amended, it was well settled that a record review could be obtained, held basically in our evidence, not submitted to all the parties, and then disclosed, but only provided that it was 3 days before the hearing. And now we've looked at the case law, Bing and I have, and it seems to me that the 3 business day rule appears potentially, it may be a substitute for the 10-day service rule, but it may also be an additional requirement. It's unclear. And there's so many ways that these things can be precluded that it's probably not a good idea to play games with them anymore, even though it was a great tool. Slide.
Yes, just remember that the third department emphasized how fairness and equity.
Right, and the 3 days may not be fair. It may not be equitable. I don't know. It sounds fair and equitable to me. Anyway.
Yeah. So to begin with our formal discussion of IME, I want to emphasize that the board greatly recognized as being sympathetic, and sometimes we would argue that unnecessarily sympathetic for the claimant. They do emphasize the carrier and employer's right to have the claimant being examined by an IME.
And it's a pretty serious right. And they enforce it, don't they? I mean, the penalties I've seen have been suspension of benefits, occasionally suspension of medical care,
Yes.
until the claimant submits themselves to an IME.
Yes,
right?
definitely. So this is why we will emphasize that the IME is very important, and if the claimant frustrates the purpose, then they get penalized. But guess what? The board would actually give them an opportunity to explain why they did not attend IME. And if they can show good cause, then their failure to appear will be excused.
And let me guess, good cause is defined very vaguely and in favor of a claimant.
Yes, it's defined vaguely, and guess what's the most cited cause for not showing up is that they have not received the notice for the IME. And yeah, this jumps to our first requirement for the IME.
Well, and just to make a point, it's funny because the common argument we make against that is, do you get your checks at that address? Because if you get your checks at that address and you didn't get the IME notice at that address, that's really suspicious. Like, you can get the money, you can collect your cash, your free payments, your cash and prizes, but you can't collect the notice that says, please go to an IME.
Yes.
And I'll tell you, this comes up in downstate cases all the time. If somebody lives in Brooklyn and you dare to schedule an IME in Manhattan, they will lose their minds, even though New York City has one of the most elaborate and extensive public transportation systems in the world. In New York City, their idea of what constitutes reasonable distance is like 6 blocks. Right? Up here, if you have to drive an hour and a half or 2 hours to an IME, a judge upstate is not going to blink an eye at that. But downstate, if you ask him to travel 1 extra block than the judge thinks is necessary, oh my God, you'd think that you'd schedule the IME in Siberia. Sorry, Dan. Go ahead.
Thanks for the comments. And let's see. So initially, the WCL section 137 require a receipt. You know, we must be able to show that the claimant has received it at least 7 business days in advance. And not surprisingly, that the claimant would often argue that they have not actually received it. And this issue was specifically addressed in the 300.2. It literally said that if the claimant asserts that they have not received the notice of IME, then the burden is on the party scheduling the IME to prove that they have sent out using a regular mail at least 12 business days in advance, or if an overnight delivery at least 8 business days in advance.
Wait a second. I'm not good at math. You started out by saying 7 business days, but now you're saying 12. Is that like a mailing rule or something? Is that like time for mailing?
Oh, I think that is might be due to the general rule of construction, the 5 business days added.
You add 5 business
Yes.
days to a mailing period.
I
Okay,
think, yeah.
outstanding. Slide.
So this brings us to the second requirement. It's generally known as the same day and same manner rule. But surprisingly, as you can see, we did not highlight the same day and same manner, but instead we highlighted on 3 other issues that we found that is really worth litigation. So let's briefly explain them in details. Next slide. Okay. So essentially, we noticed that the WCL section 137 did not contain the language that the treating physician who treated the claimant in the last 6 months. But 300.2 did contain such language. So it has been argued that the greater compliance need to be followed. But then the board issued an opinion to address this issue and essentially held that the board has constantly interpreted the 2014 revisions to require service of IME report to only the physicians who treated the claimant in the past 6 months. So the greater compliance is really not necessary now.
Right. If you just remember the headline of the workers' compensation law in New York, which is make it difficult to get IMEs, make it difficult for employers to defend files, you could guess this rule. Slide.
Yes. So this 6 months requirement still need to continue because we are still not sure what is the operative date for this 6 months requirement. So one carrier defense colleague has argued that this date should really start to count from the date that the IME5 is sent, rather than the date of examination or the date the report was drafted. And as we can imagine, it's probably a very rare case where the doctor who did not receive the report just fall outside the 6 months if you use the IME5. And this argument, I would say that is a very wise.
Right. I mean, it looks straightforward, but when do you start counting the 6 months, right?
Yeah.
And I guess you found some cases for us next slide that talk about when, like how we count, right?
Yeah.
Like when we might count from.
So what I want to emphasize on the prior cases that the board did not address that argument on the operative date of the 6 months, but instead, held based on emphasizing this concept of
Knowledge.
and knowledge. Yeah.
So the IME probably reviewed a report from that doctor that had been issued within 6 months, and yet they still did not serve it on that doctor.
And the IME doctor indicated in the IME report that he knew that this is a treating physician.
Right. Okay.
Yeah. So this jumps to our second issue, that is the reasonably known physician. So the board did not use this specific word known until the year of 2019, but then since then it appears quite constantly and frequently. So we would argue that it has to be a reasonably known doctor.
Okay, and these cases seem to demonstrate that, right? So if the documents weren't viewable in the file until the day before the exam, so that means nobody knew that the claimant was treating with this physician, that's not possible, right? Or if there's treatment, it says in very close proximity in the New York City Housing Authority case, basically, we're talking about whether the judge can infer that this is something that somebody who we should have reasonably known was treating and we should have served them or not. Okay.
Yes, so I think that this should really be a reasonably known physician, but the board till now has not really included that reasonably.
Okay.
Yeah. So the third issue is the condition that is the subject of examination. So, for example, if you have an orthopedic surgery and the report was not sent to a psychologist, that will not lead to a preclusion.
Right, because Dr. Sasson doesn't need to know what the orthopedist thinks because he doesn't even know what to make of it, right? And it's not really relevant. So this seems to me like it serves the purpose of the rule, which is to let the treating doctors know what the IME is saying about what they're doing, right? Okay, all right, I like it.
So then we still need to address that same day and same manner rule because we are still not sure who bears the burden to show that it has been properly served. So initially, we want to note that the board did place the burden on us. And as we can see, this matter of sleepy was issued last year in April. So at that time, the board is still trying to place the entire burden on the carrier. However, sorry, next slide. However, the board changed its position later last year by issuing an opinion that specifically said that the matter of sleep is disavowed.
So basically, a smart claimant's lawyer looked at the IME4 and came back and said, go back one slide, came back and said, because the IME4 cover sheet lists the doctor's names but doesn't provide addresses or lists the nature of service, we're going to find that it wasn't properly served because the burden isn't met by the carrier. And then it looks like in Catholic Health, and then you say in the progeny there where they disavow it, they conclude that just listing the names of the doctors is probably enough. And at that point, the burden is going to rest with the claimant to somehow make affirmatively prove to the court that somehow we didn't serve it properly.
Yeah, so this is definitely the case that we want to cite.
Yeah. Cool. Next slide.
So then this brings us to the third requirement. It's known as the 10 to 20 day rule. And the only for the illustration we want to introduce is that this 10 business day should start to count from, next slide please, should to start count from the date of examination rather than the date when the report was written. And also the operative date here is the date of receipt rather than the date of mailing. Well, the board did not illustrate whether this date of receipt is by all the parties. Based on our knowledge, it's really the date of receipt by the board. So actually, I do have a case to share. Well, I was assigned to settle that case, and when I did the file review, I found that our IME was precluded because the IME report was received by the board on the 11th business day. And of course, the handling attorney at that time argued that this minor deviation should be tolerated and excused, but the judge just excluded.
And when you count days like this, my recollection is that the day of the exam, if you start counting on the day of the exam day is 0, and then the next day is day 1, and then 2, and then 3, and that's one of the general construction laws. That oddly enough, basic concepts of general construction law have been appealed all the way to the third department because claimants' lawyers are really trying to prove points and settle the law about what we couldn't get away with or not. Although the concept that it has to be received by the board on the 10th day really does contravene the standard practice of law, because service on a court is deemed complete upon mailing, not upon receipt. It's basically a unique exception to any rule that service is completed upon receipt, not mailing. So it really means that they have a lot less than 10 days.
Yeah.
There's going to be a lot of overnight mail.
Yeah, but the problem is that the third department is just giving these holdings, and they are followed. So
that's pretty terrible.
So next slide, thank you. So the fourth requirement is on the provision of information, and our summarization is that do provide whatever that is given to the IME doctor to all the parties, including the board. But there is a side note to put. That's on the next slide. Thank you. However, be sure to avoid sending duplicate informations. So I first saw this comment on a subject number. I believe the number is 046666, which says that if you submit duplicate information, then it would lead to preclusion. And I doubt if it was the strictly enforced since it's quite common to see duplicate information on e-case.
Right, and it's hard to know how it got in there, right?
Yeah.
Because the board scanning vendor separates stuff all the time. So there could be duplicates in there that could have been sent under the IME3 cover by the IME vendor, and if the board scanning vendor like separates it, we have no way of knowing where it came from, right?
Yeah.
Like who the source of the information. I guess conversely, a judge could see duplicates in a file after an IME and try and argue that they came from the vendor, but there's no way to prove that. Like the judge could show, oh, I'm precluding it because that obviously came from your vendor, and we could be sitting there in the courtroom saying, no, we have no way of knowing where that duplicate information came from.
Yes. So initially I thought this is a joke until I did the case law research. So next slide.
It's not a joke.
It's not a joke. We found two cases that the board did invoke and enforce this rule. So while it's not very frequently invoked, but if it happened on your case, then probably it will be precluded. So please do give some caution.
It is very common practice when counsel are working on arranging an IME that counsel will take steps to make sure whatever information that needs to be in the file, like particularly I'm thinking about surveillance, is placed into the file before the exam takes place, so that the vendor can operate under the assumption that they need not submit anything into eCase other than the doctor's report and potentially any intake sheets or cover letters that might have been provided during the course of the examination. So that sort of like is a way that we prevent that problem, is just to ensure that there's record integrity before the examination goes out. Because I'm always, we have outstanding vendors that we work with, but because there's oftentimes a lack of coordination, that we don't want them operating in a silo, it's easiest to just simply let them operate under the theory that they don't need to be part of this process of submitting documents. Everything that the doctor needs is already in eCase. They're going to be grabbing that information from eCase and relying on that so that they know if they submit a report, the only things that the doctor has looked at have already been in eCase, with the very specific exceptions maybe of the cover letter or again the intake sheet.
Slide. I think that's really the best practice.
Yeah. Yes. It's clean. It's clean and neat.
So the fifth requirement is about the communication with the doctors. So the rule of thumb is that if you have any written communication with the doctor, just submit it to all the parties and the board.
That sort of seems to satisfy the first rule, for sure. But then, of course, there's a whole bunch of rules about what constitutes, essentially, and for our purposes, what constitutes a leading or improper IME cover letter, right?
Yes, and this is addressed on the next slide.
Right, that's the biggie.
Yeah, what is the undue influence? So on this slide, we'll see two case laws that are communications between the carriers and the IME doctors. So in the first case, it was held to be unduly suggestive when the carrier used the forbidden word once again. The boss thinks that this just emphasized the report and suggested the doctor to give more weight to the reference report.
This is a problem that comes up a lot, a procedural problem that comes up a lot in workers' compensation is, no matter what we do in terms of preparing cover letters to guide the doctors and to try and point out what issues they need to address, there always seems to be, I call it a QC, like a quality control, a question check error. IME vendors get their reports from their doctors, they transcribe them, and then somebody usually looks at them to make sure that they're responsive to the issue for which the IME was set up. And a lot of times, IMEs come back having ignored the cover letter or ignored the questions or ignored the issues for which the IME was scheduled. And then we have to go back to that same doctor, because you don't want to get another doctor because that's just doctor shopping, right? But we go back to that same doctor and say, hey, you missed this topic. Please comment on it. And I guess I'm loath to say that this is much of a rule, this once again thing is much of a rule. It could have been said, maybe they would have gotten away with it if they had written, hey, we sent you a cover letter, we asked you to comment on apportionment, and you didn't comment on it. Please comment on it. As opposed to sending the records that support the theory of apportionment and say, you need to look at these again, dummy. Because if you had looked at them, you would have told us something that we would have liked to have heard. I guess that's the way the board read it in that case. But, I like the second rule, the Nassau rule. which is just basically, as long as you're quoting from the medical records, you're good, right? And sometimes you get the privilege of quoting from a medical record that already has IMEs in it, and the IMEs may have said favorable things for us. And so sometimes you can quote an IME to themselves. You get an IME that says this claimant is not trustworthy and has flubbed the exam and has a prior history about which they lied. And now you're getting your second IME, and you just basically lift that quotation and put it in yours and say, hey, we had this IME that said this, right?
Then a question came to my mind. I was wondering, what if, let's say, we draft a cover letter and say that attached for your review are Dr. A's report, Dr. B's report, Dr. C's report, which says blah, 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 blah. Well, Dr. D's report, Dr. E's report.
I mean, we could do it that way. I mean, the way we draft cover letters right now is we provide a background of the claim. We don't just ask questions in the RFI, the request for information section. We draft a background that typically provides a recitation of the medical records that we believe are probably the ones most relevant to the questions we're asking the doctor to comment on. So if the doctor bothers to read the cover letter, they're going to get a flavor of what really is going on in the case before they then dig into the records themselves and develop a medical opinion on it. Yes. But, not all the time do we get reports back that demonstrate that the doctor read the cover letter. Next slide.
So on this page, we have some communications between the treating physician and the claimants. We think that they are of value because similar analysis can be used. And so I'm actually surprised to see that the board thinks it's okay when the claimant asks the doctor to opine on the issue of the level of permanency. I think that actually suggests that the claimant has reached
that there has to be permanency, right?
Yes.
It precludes the option that there is in fact no permanency.
Yes.
It should say your medical opinion on the issue of permanency, if any,
yes.
Right? That's what we would write. And if we wrote if any, they would probably argue that it's suggestive, but the claimant should do the same thing, because if we were to just suggest that it is present, I mean, the first one, the W.F. Johnson case, makes sense to me, right? Because the counsel is kind of telling the doctor explicitly. In the leader offense case, they're just sort of suggesting it implicitly, which is worse. I think it's worse to implicitly assume it in the way that you phrase the questions. I have made that argument, and other attorneys at our firm have made that argument, that the way things are phrased didn't suggest that the doctor had options other than to find permanency or to find a disability present. So I think it's unduly suggestive, but I think a lot of this has to do with the predilection of the judge and the circumstances of the case.
Yes, and
next slide.
This connects us to the final topic, and it's really my favorite topic. It's the offensive use of the procedures. I was wholeheartedly delighted when I drafted this slide, because previously we summarized the 5 requirements that we as carriers, as defense, we must satisfy, and it's very passive. But here, finally, we have an opportunity to use the rules we just discussed offensively and aggressively. And the magic here is to establish that the claimant's treating physician is not really a treating physician, but instead an IME. So
this is the Estulans case.
Yes.
This is the baseball bat that a defense counsel loves to use when claimant's attorney starts to try and get tricky, right?
Yeah.
They're trying to get tricky. Next slide.
So here are several case files we found on the treating physician's status. So in this case, we found that the treating physician merely repeatedly provided the claimant with an opportunity to produce further medical evidence, and these are direct quotes from the board's opinion. And my understanding of that language is essentially that this doctor only examined the claimant once.
There was Dr. Hecht. There was a game being played downstate by a counsel, intentional game. It was clearly planned. It was orchestrated. Downstate claimant's bar. What they were doing was they were using Dr. Hecht to give permanency opinions because he gave decent permanency opinions and he was pretty liberal in favor of the injured worker. Next slide. And in the first case, they struck it because the doctor just saw the doctor saw the claimant, and the claimant hadn't had treatment for years. But then they tried it again, and they tried it the next time with 2 visits. So they'd have Dr. Hecht basically do an intake and assessment visit, and then a second visit to assess permanency. And those were shot down, right? Yeah. The two visit Monty wasn't good, but then the matter of fire department, the 3 visit Monty works. So 3 is apparently the board's magic number. It's every lawyer's magic number is 3, right? Yeah. 3 of everything, 3 arguments, 3 of this, 3 of that, right? We love it. So if Dr. Hecht sees 3 times, then they're going to agree that he established a treating relationship. But the thing that makes it painfully transparent is that there's a line of cases that demonstrates that this was an orchestrated strategy so that they could get Dr. Hecht into cases when they wanted him, but not have to worry about him being a real treating doctor.
And I really don't like that the 3 times still include the permanency examination.
Right, because the 3 times doesn't actually change the analysis, does it? It just changes the number. It doesn't change anything he provided to the claimant or didn't provide in terms of care or treatment. It just means he's had FaceTime with him 3 times. It's ridiculous. Oh, well, that's a silly rule. That's a really silly rule. Next slide.
So before we jump to our second larger topic, I do want to summarize the IME part and give a disclaimer that the 5 major requirements: the 10-day rule, the sufficient notice, the same-day, same-manner rule, the provision of information and communication with the doctors are the major 5 things, and they are not intended to be an exclusive list of the requirements.
Right, because there are no rules, but there are a lot of rules.
Yes.
Let's talk about cross-examining medical witnesses, because I can tell you what, I've been burned in effigy over this because our office is pretty assertive when it comes to downstate cases about scheduling. So let's tell the folks at their desks, hopefully eating a really good lunch. I hope you guys have good lunches out there. How this really works and what it looks like, how the sausage is made of litigating and taking testimony.
Yes, and before we start, I do want to give a general comment on the second part. So this is really because since I have started practicing in this field, I have been argued multiple times by the claimant's counsel for the petition that the claimant's cross-examination of an IME doctor is somewhat like unlimited and unregulated. And I really don't like that. Whenever I present a case law to them, they'll be able to pick certain language and say that, wait a second, isn't it true that the board is essentially requiring the carrier or the employer to satisfy those requirements rather than saying that the claimant is bound by the same rule? So
right.
That's the bigger topic here, and we just noticed that since the end of last year, the board is kind of realizing this problem. It's trying to giving opinions to address this problem.
Yeah, so that's very true, and I wanna talk about that for a second, because about 16 months ago, our office has forever aggressively taken the position that if a claimant requests cross-examination of an independent medical examiner, the claimant's responsible for arranging that deposition. We used common sense when we understood that concept and said, if they're responsible for arranging it, that means they're going to make the phone calls, they're going to get the dates, they're going to arrange the court reporter, and they're going to circulate call-in information or properly serve subpoenas, what have you. They're going to do the same process that we do. But starting with a lot of our downstate practice, we found that the claimant's bar really didn't want to do it. They really didn't want to do it. And I'm going to be jaded here and make sort of a generalization, but it's based off of a bunch of anecdotal evidence, is that they don't want to expend the time to do it. They don't want to expend the work. They don't want to expend the money, and they want to be able to do it for free. Not just free in cost, but free in time. And they want it to be done by somebody else for their benefit so that they can focus on making themselves money.
Yes,
right?
I hold a hard for you.
And so About 16 months ago, the board, the downstate bar, got very aggressive with us, and we ended up being penalized in a case over a particular issue that now, 16 months later, the board has issued case law that entirely is consistent with what we were doing 16 months ago and what they penalized us for 16 months ago, which was essentially forcing the claimant's bar to actually do the work. And all along, our position has been, if the claimant's attorney wants to litigate an issue by including cross-examination of the treating doctor, they need to do the work for it. We're not going to. We're not going to actively prevent them from doing it, but we're not going to do their job for them. And if they fail to do it, they should burn for it, right? They should take the hit. All right, next slide.
So actually, 1 second, can we stay on the slide? So I just want to explain that's how this problem initiated, because the cross-examination of medical witness is generally governed by the NYCRR 300.10. And if you look at the language, you'll be surprised to find that it only talks about employer or carrier. And the board in this decision literally acknowledged that the claimant's opportunity to cross-examine a carrier's IME doctor is not specifically provided in any statute or code, but is permitted under the tenets of due process. So it's not regulated by any code or statute, but will be able to cite to binding authorities. That is the case laws we are going to introduce in this presentation. So this is a case I really love, and this is one you provided for me when I got trouble with legal research. And as we can see here, the board first clarified that the claimant attorney is the party that is the proponent of the deposition of IME doctors. And as a result, they should pay for all the related fees. And that includes the stenographer fee, because maybe you cannot believe, but we've been arguing that the stenographer fee should be paid by us rather than them. And this is other cases that exactly on point. So any fee related to the scheduling of deposition should be borne by them. However, the claimant's attorney will be able to get a later reimbursement once they submit an attorney fee request.
This is, you guys will be surprised, this is new. And it's new that it's this clear. It's in the last 6 months that the board has actually said clearly, A, they have to arrange the stenographer. Claimants' attorneys were fighting with us that they didn't want to provide call-in numbers for the deposition, let alone arrange the stenographer.
Yes.
And we were saying all along, like, you can arrange whatever you like, but if you don't arrange a stenographer, you're not having a deposition. You're going to have a conversation off the record with a doctor because there's no stenographer there. And we're not paying for it in the first instance. And the board has now finally said, yes, they have to provide the call-in numbers. They have to provide the stenographer. We are going to still have to pay for it in the end. But they have to front the costs, and then they have to request it as a reimbursement on their fee application. And these cases, SPJ and a few others we're going to look at later, stand for the proposition that that's exactly what has to happen. And if they forget to request the fees on their fee application, they can't just bill us, the carrier or the defense counsel, for it and hope that it's reimbursed. They have to eat it. And I like that, because that means they actually have to pay attention. Next slide.
So this goes to the first general topic in the scheduling of medical witness. And here we see that the board issued this famous case law, Raymond Desmar, to explain the proper procedures. And I remember that when I was trained, it was on the must read list.
It is. It's a required reading. It's one of the cases that the board actually publishes on their website. And I think it's got a lot of details in it, right, Bing? I mean, it's a very long decision, and it's very detailed. A lot of if this, then that, if this, then that, if not this, then that. It's very complicated, but it's inclusive. But essentially, I've always read it, and I teach it when I lecture on it. I always teach it as essentially the board's theory about this process is it has to be done fairly and in good faith, and they want the testimony. They don't want game playing.
Yes.
So if you have done what you need to do, if you are behaving fairly, if you're trying to locate the doctor, trying to get contact with them, trying to get in contact with the claimant's attorney, and something is happening that's thwarting your ability to do that, you can request an extension, right? And it should be granted. But if your opponent is playing games or otherwise misbehaving, right? If the doctor is ignoring us, we can't find the doctor and no one can help us find the doctor, claimant's attorney is being obstreperous, you can ask for an extension. You can also ask for preclusion, right? I mean, that's what Raymond Desmours really lays out, is whether the evidence is going to be precluded or whether the cross-examination request is going to be found to be waived for an insufficient effort to obtain the testimony.
For sure. And I remember the comment I wrote down is no gamemanship.
No gamesmanship, right?
Yes.
No playing games.
But
don't screw around with this. Do it fair and honest. Be transparent, right? This is one of those things that will worm its way into one of your cases big time if it's not done properly. Next slide.
Sorry. One second. I do want to emphasize that, in the beginning part of this case, the board did include this specific language that, this clarification is not supposed to apply to the cross-examination of the carrier's consultant by the claimant. I was very troubled by this one, and until we found the case law that addresses this problem. So
next slide.
Thank you. So this matter of human resource administration is the one that solved the problem, and guess what? It's so fresh that it was actually issued last month.
Yep.
So it essentially cited the Raymond Desmours and applied the exact same analysis framework, and most importantly, it used the word that it is a proponent's obligation rather than the prior case laws that you said that it is the carrier's obligation. So I really love this case, and I wish to see more case laws citing to human resource administrators.
Right.
So next slide. So this is the board's procedure for getting a second adjournment. A second adjournment is actually the grant of the request for extension because the deposition itself is the first adjournment.
Right.
And the magic word here is sufficient cause. And we'll see how the board determines if this is a sufficient excuse. So
right.
On the left, we see that the board totally agreed that if the doctor was engaged in any emergency, performed surgery, or had some hospital commitment, that is sufficient cause. And on the right, we see that unwillingness to testify is by no means tolerated, and also that
Sorry, we had a little technical glitch here. Sorry, everybody. And then the right one is just unwillingness to testify, right? So we go from the accident, or a doctor having an emergency surgery, which I think is BS, by the way. I've been convinced in the past that I've heard excuses that were just flat out lies. The doctor is actually playing golf, but he had to go to the hospital. I mean, come on. It's a joke in Caddyshack, right? Emergency surgery and he's playing golf. But then unwillingness to testify. Basically, this is the same concept, right? Fairness and accuracy, right? If a doctor just shows up and doesn't explain themselves, I mean, the only case in the appellate division that we've ever seen that had this issue ruled in favor of the board, who precluded the evidence because the doctor failed to appear and no explanation was ever provided.
Yes.
Right? And they just said, without an explanation, the doctor didn't appear. We don't know whether it was good or not. So we can't say that the board's decision to strike it was an error.
So the explanation can never be two-way, and the
Yeah.
court need to be able to make a reason determination, and that's the right.
And this is where it's one of those things that our office, working on behalf of you, our clients, our staff are trained that when a doctor no-shows or a doctor tries to do a late cancel, we push for an actual explanation. And we do it out of compliance with the law and out of fairness because we know that Raymond Desmore says we need a legit reason, right? So if the IME doesn't appear, the vendor can't just tell us he's not available. We need to know the actual reason, right? Or if a treating doctor's office calls and says the doctor can't appear, and it turns out that it's a BS reason, that information goes, well, whether it's good or not, goes to the handling attorney, who can then say on the record at the deposition where the doctor has failed to appear, we call those blown or busted depositions, place a statement on the record, my staff spoke to the doctor's staff, and the doctor's staff has informed our office that the doctor's unavailable. We attempted to get further information as to the nature of his unavailability, and they refused to provide it. I mean, even me, occasionally I'll say, I'm just going to assume that the doctor's playing golf, right? This doctor's testimony should be struck. He wasted our time, he wasted our resources, he wasted the court's time, because, Judge, you're going to read this statement on the record and go, what the heck? I was hoping to read a depo so I could get this case finished. Now I've got a new issue, which is whether this doctor is being a jerk or not, right? Judges don't want that. That's sprawl. But you know what? We had a decision come down this week, and it's not the first. We've had 8 or 9 of them in as many weeks and months where the board or a judge has made a ruling adverse to our opponent on the grounds that their witnesses didn't cooperate with us scheduling the testimony, right? They played games. Next slide. Right? And this is all about the last adjournment, which would be like, okay, they adjourn the case to take testimony, they give an first extension. Getting in a second extension is just like, it just doesn't happen really. Like judges, when it's extension 2, unless somebody's dead or ill, you're just not going to get it. And by the way, you've handled a lot of cases now. You know that by the time we're looking at potentially filing a second extension request, we're probably at that point saying, yeah, we'll file an extension, but what we're really doing is we're filing an affidavit that says you should probably just preclude this doctor from testifying and strike his reports because he's not cooperating.
Yes.
And there's no reason for us to ask for another extension, right? Because Raymond Desmore's, again, just comes down to, this whole process comes down to whether you have a record of activity when it comes to scheduling the depot that supports the doctor being precluded or a waiver against you, right? And if you've behaved in good faith, if you've said all the right things, if you've expressed a desire through your actions to take the testimony, preclusion should occur, right? Cassie Crispin from our office had quite possibly one of the most disgusting and difficult claims I have ever seen. It was for a sight condition. It was due to somebody witnessing a death, a traumatic witness death, like literally a person died in this employee's arms. And he had produced a whole bunch of medical from a psychiatric practice that refused to allow their providers to testify, citing several provisions of the state mental hygiene law and some other things that were ultimately bull. It was ultimately bull. There was no reason for these people not to testify. We could have gone in guns blazing and said, you're wrong, you're full of it, you need to testify, we shouldn't have to give you releases, we shouldn't have to satisfy whatever stupid belief you have about whether these people can testify or not, they need to testify. Instead, we took the position that we were going to be kind and gentle, and you catch more flies with honey, and we took all kinds of time to satisfy these people that they could testify. Claimant's attorney even came and said, yes, we'll provide you with a release. That's what you need to testify so that you can support my client's case. We'll give you a release. We said, fine. We went to a blown deposition, and we laid this all out, and we said, we're not looking to preclude these people right now. We're looking for an extension because we think that they're working in good faith. Claimant has said they're going to get them a release. So we really want to take this testimony because we know the court wants a transcript of testimony. The court doesn't want to see more of these blown deposition statements. So claimant's attorney says they're going to do this, and we even put on the record exactly what had to happen for those doctors to appear and testify, and claimant's attorney said they'd do it. What do you think happened when they didn't do that and we couldn't get a testimony?
Precluded?
Both doctors' reports were precluded. The claim had no medical evidence and it was disallowed. And it was the funniest hearing in the world to listen to because the judge made all those rulings and the claimant hadn't said a word until the very end of the hearing. And as the judge is turning off the hearing transcript, you hear the claimant say, "What the hell just happened?" It was hilarious.
Yeah.
Next slide.
So the third adjournment, the criteria changed to extraordinary circumstances, and we see that this is a heightened requirement. I really found this interesting, the matter of continental food, where the board found that being located in another continent is an extraordinary circumstance.
What does that mean? He went on vacation?
I reviewed through the record.
He went on vacation to Brazil?
Yeah, why he was in Greece. So.
Oh, what? He was in Greece?
Yes.
Oh, man. All right, next slide. The doctor was in Greece playing golf.
But at least we do know that an office mix-up is not an extraordinary circumstance. So while a scheduling conflict might be a gray area for the second adjournment, it would definitely not be an extraordinary circumstance and thus not excuse for a third.
A death in the doctor's family isn't an ordinary circumstance too. That's ridiculous. That doesn't even make sense. I would grant that extension.
Yes.
And I'm a jerk.
I agree, and I think that makes more sense.
Can you imagine me as a judge? I would still grant that extension. I'd be like, the guy's family died or something. Somebody died, close family member died. Of course, I'll give you an extension. That would be fair. All right. Well, but we're dealing with the board. Next slide. They want to get decisions, right? They want decisions done quickly.
So
churn out those cases.
We are to the point that if we have exhibited that we have used all the good faith efforts, then the doctor still did not show up. We cannot develop the record, then whatever opinion there must be quickly.
But this is where we start talking about subpoenas, though.
Yes.
Melissa once said that I treated subpoenas like a 6-year-old treats like a toy Superman cape. Like I pretend like it's I thought it was my superpower, right? Because subpoenas are really one of the big differences that appear in a lot of these cases. What we've really described to you so far has only been under the assumption that we're scheduling these what we call on consent, where the parties all agree to a date and we simply circulate a cover letter, as opposed to formally serving the doctor with a subpoena that has force of law and has additional ramifications in this process, right? If we can go to the next slide, we can talk about that a little bit. Because the subpoenas really make a difference. And basically, the law says that if we're going to issue a subpoena, we have to follow the CPLR, right? And that's SPJ piping. That case law is actually really old. That case law goes back 4, 5, 6 years, where it says if you're going to use a subpoena, you have to follow the rules, right?
See, the holding is really old, but I reviewed 31 cases on that point to just pick this SPG because that is the only case that had a correct citation. That is basically, if a party chooses to subpoena the doctor, then the party is required to follow the CPLR.
Right.
So, for all other cases, you see, is if a party chooses to subpoena, then the carrier is still required to follow. And I really don't like
Right, that's true. I like that. And basically what this boils down to is the stock language for litigation directions does not mention subpoenas. A judge has to go out of their way to direct a party to subpoena the witnesses. A lot of judges do that as a normal course. They'll say, I'm directing litigation, these doctors will testify, the parties are directed to issue subpoenas to obtain their testimony. But that's not common. That is not the stock language. The stock language just says the party shall arrange the testimony, right? And so we, as a matter of course, use subpoenas. And when we use them, we follow the CPLR and the service rules. But you could arrange a deposition on consent. The doctor could fail to appear. And then your next step would be to get another date and then issue a subpoena the second time. We elect to subpoena the doctors in the first instance because, as you'll see, the use of subpoenas actually changes the outcome in certain circumstances. Next slide. And it changes it more favorably to the party who's using them.
So actually, I do want to add one comment. So interesting, in Raymond Desmar, the board cited to the 300.1 barrel and held that if a second adjournment is granted, then the judge must
order a subpoena. But that assumes
but it's not
followed. Yeah, it's not followed. That assumes the judge knows the law. And Raymond Desmore's they should know, but they don't. Next slide.
So,
Or at least not all of them. Some of them do. But I've actually had judges downstate find waiver when they should have found preclusion.
yeah.
And I don't understand, like they get reversed on appeal, it just wastes time.
So the governing statute is the CPLR 308 and give us 4 routes to satisfy a proper service of subpoena. The first is very very rarely used because it's a personal service to the doctor himself. The fourth is a catch-all that says that if 123 is not applicable, then follow whatever direction of the court.
Right. Step one is like basically, like handing somebody a piece of paper and saying, you're served, you're going to testify. Step two is personal service, but it's on a business address.
Yes.
It's just anyone of suitable age that acknowledges that they work with the person, you serve them personally. It's still personal service, but a different kind. And then 3 is nail and mail.
Yes.
And then 4 is the manner directed by the court. But those 3 and 4 typically don't happen. 3 happens when we can't find the doctor, usually. Next slide. And then it's the 20 days notice rule, right?
Yes.
You have to give 20 days notice for non-party witnesses.
Give the doctor 20 days, yeah. So next slide. So actually, in one case, we did make an argument citing to a body decision that it could essentially be 30-day notice, but we do want to caution you that this could be a double-edged sword because
it could work against us too.
Yes, it can.
Yeah, this is the whole general construction law allowing time for mailing, etc. Next slide.
So the final topic is when we cannot locate the doctors, and there are 3 outcomes. So the first is that if there is still one available route to contact the doctor, then the court will just grant an extension and give us a final opportunity. But then the situation is different. So next slide. So the situation is different when the doctor has essentially disappeared and there's no way for us to locate it. Then it's either that we have waived the cross-examination or the doctor's.
That's if you haven't done your due diligence, right?
Yes.
If you haven't behaved, if you haven't followed the mantra of Raymond Desmore's, which is we're trying to find the doctor, we can't locate the doctor, all we can do is serve a subpoena to the last known address. And then they told us they don't know where the doctor is, right? That seems to me like that should result in preclusion, shouldn't it? If we genuinely are behaving ourselves and can't find... You know what's funny, too, is that this is a matter of Bed Bath & Beyond, so the doctor must be in the Beyond section, and he's missing. Next slide.
So we did find 4 case laws that authorize the preclusion, and I specifically like the language that in accordance with precedent. So this is the case law.
In accordance with precedent, okay.
Yes.
And we also determined that of the cases we could find that talked about missing doctors, the important distinction that the turning fact that went from either waiver or preclusion was whether the employer or carrier had issued a subpoena in the process,
yes.
had served a proper subpoena, even if it was on the wrong address or an address where the doctor is not.
Yes.
Right? The guy's missing. We can't find the guy. The board wants to see that we served a subpoena because that subpoena, much like the little boy's cape, is our legal authority. It's like our Tomahawk missile. It has power behind it. We fired it off at the place that we thought that the doctor should be, that he was last known to be, and it had the force of law, and still we couldn't get the doctor's testimony. That's when the board's going to say, yeah, this doctor's disappeared, and guess what? You've tried your best. You can't get it. I'm striking his reports because you can't cross-examine him, and the doctor hasn't made himself available to testify. Right?
Yes.
That's the big distinction.
That makes sense. Yeah.
Yeah, I mean, it makes sense, right? I mean, it's a Raymond Desmore thing. It's like you followed the rules, you played nice, and the opponent didn't do it. And the reason that this has worked out for us so well is our opponents don't want to play nice because it's making them do work that they don't want to do. It's work that they didn't factor into their staffing. It's work that they didn't factor into their budgets. It's work that they didn't factor into their own personal day. They want us to do it all for them. And they want us to be penalized if it doesn't work out in their favor, right? And I'm thinking about certain judges. It starts with an M and ends with Iller. that they want to penalize us if for whatever reason a doctor's testimony can't be taken. When in fact, what should happen is they should be penalized. Next slide.
So I think this brings us to the end of our presentation.
We finished with like 30 seconds left. 30 seconds left. There was a lot of information. We threw a lot of information. This was a great presentation, Bing. I thought it was outstanding. Do we have questions from the audience?
No, we're good.
No questions? Nobody's got any questions? This is really cool. This is a really cool topic. It causes a lot of fun discussion in the office because the staff get involved in sort of the what I'll call the claimant's attorney's hissy fits, because that's where this all comes from, right? It's a staff member who, in our case, are very highly trained and are familiar with the law, interacting with staff members from downstate law firms who are just pissy and angry and rude, and they're yelling at our staff. And sometimes the attorneys from the downstate offices are yelling at our staff. Or basically what happens is there's a proxy fight between our attorney and their attorney with the staff in the middle of it. But the problem is that no matter how loud you yell, right, and no matter what words you say, if you're not following these rules for scheduling depositions, if you're not behaving in the correct manner, if you're the person who throws the rocks, you're going to get hammered. You're going to get hammered. And then what happens is Cassie Chrisman comes in and punches you in the face in the middle of a hearing, right? And you lose the entire claim. And then we win an entire claim on a procedural defect. Or Paul Kornacki gets a permanency opinion struck, and then they have to implement the IME, which gives a 0% SLU for somebody who, when you look at the record, it appears that they probably did have some permanency that should have been compensated by a schedule. All because you can't play nice, and you can't follow a rule that is followed in every other form. That's the part that's funny, is that the principles of Raymond Desmore's are essentially somewhat abstractions of the CPLR, which is followed in almost every other form in New York about how to take testimony. If you're in a civil case and you want to cross-examine a non-party witness, you're going to arrange it, you're going to pay for the stenographer, you're going to pay the witness fee, and you're going to pay for the room that you have to take the deposition in. You're going to bear all the costs, except in comp. The claimant's attorneys got complacent. They thought that they could use requesting cross-examination of our IMEs as a stick because it was going to cost us time and money, right?
So I think this just brought us to the circuit. Like, we are back to the one-line rule. Stay with the fairness and the equity.
Yeah.
Yes. So the good faith efforts.
Don't be a jerk. Or if you're going to be a jerk, save it for when you're right. Right? Save it for when you're right. All right, guys. Well, we've gone way over time now. So sorry about that. I hope you had an entertaining lunch. For Bing and myself and the law offices of Melissa Day, I hope you have a great weekend.
Yeah.
Thanks.
Thank you.